about 6:30, so we're going to kind of get started here because we have several very well qualified speakers who are going to speak to us, and I think it'll be very helpful to folks. My name is Stephen Miller. I'm a family physician here in Peterstown. I am affected landowner of the pipeline and been involved with the Save Monroe group for close to 3 years now. This was sponsored by Save Monroe, Scrap from Summers County, and the Power Coalition. So we want to thank them for all the work, and especially Nancy Bolden for all the work that she's done in getting this together. When you come in, if you haven't, there is a sign-in table. If you could sign in, and if you have an email address, we'd like to get on one of our email lists. We'd like to have you there. You may already be on. I see a lot of familiar faces here already. We do have water and pizza and goodies over there, and help yourself. We do ask if you help yourself, give those folks a donation, because right now we are trying to raise money. It's very important right now. So if you haven't on the way out, stop and give them a donation. I think the restroom is over that way. Let's see, was there anything else? Restroom there and over there. Okay. The folks that we have are going to speak tonight are all attorneys. They're well experienced in pipeline issues and eminent domain issues. This may be somewhat geared toward landowners, but it is also geared toward everyone. It is really vitally important for all the affected counties to really come together and work together, and that has really become more of a movement recently, not only with Summers and Monroe County, Giles, and we have friends here from Montgomery County tonight. I think that it's become increasingly clear that these counties, these affected counties, are really being targeted as an energy corridor. There's no question about that. So this is kind of the tip of the iceberg. If this project is approved and goes through as it's planned, as they want to do, this is going to be a major problem for all of these communities in the future, because this won't be the end of it. This will be only the beginning, because there's a major movement for export of fracked gas, and that's pretty much what this is all about. So our first speaker here is Roberta Durant. She is an attorney, and she is very well experienced, and she's going to, you want to come on up?
Oh, right, okay. Is that good? There, you guys can hear me all right. Thank you. Appreciate you all having us here. My name is Roberta Durant. I go by Bert. I'm from Bent Mountain, Virginia, which is about half an hour south of Roanoke, and I got involved in this pipeline challenge about 2.5 years ago, when the pipeline was announced for crossing our beloved 4,000-foot Bent Mountain. And we're in a bit of a geographical oddity there between Roanoke and Montgomery County, and the geography, the upland plateau and the watershed make for a nice community, just a physical sense of community where we come today. And about 28 landowners, and they're all thick in it. As of January, they'd signed one easement. We can do this. And we can do it together. And so my theme there is our coalition with your county here, your Virginia counties, the West Virginia and Virginia counties have become part of the Power Coalition, which was formed with the efforts of my friends Lori Artisan, Ellen Darden. You guys, I'm going to call you out and stand up. Russell, April Keating. These are our executive committee members, and if you're a steering committee member, you participate in any way, please also, rise and take a bow. We appreciate your work. Thank you. Without further ado, I'm just going to run quickly through our host of attorneys this evening. Chuck Lawler is here with us from Norfolk tonight. He and his son Chip have a practice together, Lawler Law. They specialize for private property owners. He has a passion for defending the constitutional rights of private property, and he's made a career of it. And he attends here tonight, and I'm going to introduce his friends, Joe and Jackie Stevens. Chuck's intention is to, in the event necessary, to work easement and eminent domain work here in West Virginia, and would partner, among others, with both Chip and these folks. So thanks for joining us tonight. And they're from Hamlin, right?
Joe and Jackie Stevens, Stevens Law Firm in Hamlin, Lincoln County.
Chris Johns is here with us tonight and hails from Austin and Houston. Get that right?
That's right, originally from Buchanan.
Okay, originally here from Buchanan, Virginia. And
West Virginia.
I'm going to keep doing that. I've chided somebody else for continuing to do something like that, so bear with me. I know where I am. I'm a little sleep deprived, so I'm going to take that excuse. So Chris actually is the founding partner of Johns, Mann, Ellis, and Hodges in Austin and Houston. He teaches at the University of Texas and has a specialty, among other matters, in pipeline, in the particulars of pipeline eminent domain work. And he'll share with us on that this evening. He talks specifically with regard to the effects of pipelines in the right-of-way, and he's prepared to address cutting-edge issues in eminent domain work. And next to him, I'm not going to let you out of this, Isaac, is Isaac Howell with Appalachian Mountain Advocates. And Isaac, you all are likely familiar with Isaac and his work along the MVP thus far. He has a private... Yeah, and alongside Isaac, Ben Luckett is with us here tonight. Ben specializes in FERC study and work, and in particular, our concern here is with the tolling orders. He's done a tremendous amount of work there. He has filed in West Virginia the appeal of the Department of Environmental Protection of water quality permits, and that's pending. And together, AppleMed has worked the McCurdy case. Rah, rah. Yeah, I wish we had that good fortune in Virginia. I've been out chasing surveyors for 7 days. We just had another round here, just pre-FEIS. Tammy Belinsky, I don't know if Tammy's here with us yet. Okay, Tammy is here from Copper Hill, Virginia. Tammy specializes in environmental law. She has partnered with others and is now in solo practice on her own in environmental law and litigation. She has a specialty in forestry. She was a forester before becoming an attorney, and in DEQ and water quality issues. So thank you for being here with us, Tammy. She's going to talk about the Forest Service issues and the potential for a 500-foot corridor. I think that's about it. And I'm going to cede whatever 2 minutes I may have here for Maury, talking about the
Appalachian Trail.
Appalachian Trail.
I'm just here. I'm here on behalf of the Appalachian Trail Conservancy and the Appalachian Trail Club in Roanoke. We was hoping they would get over here. Andrew Downs, the executive director, has been trying to get over here. We just can't get it worked out when they can get here. He is actually on the way to Washington, D.C. to meet with a number of senators and congressmen. Dana Costavos wanted to come, but she had another meeting over there in preparation for their meeting on Thursday and Friday. The Appalachian Trail has never opposed pipeline. They've worked to try to put them in better places and make the things less. This pipeline, they're totally against. They're fighting it tooth and nail. And they tell you all that. They'll be here sometime this summer. We will try to start a trail club back over in Monroe County, but they're against this pipeline. And I just wanted to let y'all know that they wanted to be here. And anytime you can support the Appalachian Trail, they've been a great supporter of ours.
So y'all understand, attorneys have been given a handful of questions that they may have folded into their talk tonight, but we will open up for a variety of your questions, and in particular geared towards the questions of landowners in the right-of-way at the end of the program. And again, there have been some particular questions that you all have forwarded to Nancy and Susan. So can it maybe have a show of hands, how many landowners here? Landowners and peripherally affected landowners? Hey, the community, yeah. That's how I'm defining us, by watersheds. Dr. Pam Dodd says, you know, she defines us by watersheds and sub-watersheds, and you know, it's the thing that brings us all together, in my mind. We'll talk a little bit at the end of the evening about water testing. All right, thank you.
Okay, well, so before we have, you know, a few folks talk to you about what to do if it looks like the pipeline's going to come across your property, I'm going to talk to you a little bit about what we're trying to do to keep the pipeline from coming across your property or coming through your community. I work with Appalachian Mountain Advocates. We are a nonprofit environmental law firm based up in Lewisburg, and basically we represent environmental organizations, community organizations, free of charge, to, you know, in various environmental cases. We've done a lot of work in coal mining in the past, but it seems like the threats that have presented themselves more recently are these big pipelines that they're trying to build to take the gas out of the fracking areas in northern West Virginia and Pennsylvania, and coming through a lot of these pristine areas like Monroe County and like Giles County and Franklin County and the adjacent counties in Virginia. So our work is primarily under federal environmental statutes. There's 3 laws that we're primarily working under here that we think give us the best opportunity to stop the pipeline. The main one of those that the pipelines are authorized under is called the Natural Gas Act. And that's, if you've heard about FERC, the Federal Energy Regulatory Commission, they're the ones who administer the Natural Gas Act, and that's how they authorize pipelines and give them the power of eminent domain. And the basic question that they're required to answer before they can give a pipeline the power of eminent domain is this in the public convenience and necessity? Is this needed by the public? And what we're trying to, the claim that we think presents a pretty strong legal claim is that they haven't shown an actual public need for the MVP. They've shown that, yes, there are some entities that would sign contracts for the gas to be shipped along the pipeline, but those are actually corporate, under the same corporate umbrella as the company that's building the pipeline. So these are, you know, not arm's length deals, right? It's almost like an insider trading type of thing. Like they're creating their own need for the pipeline. And so we've gotten studies commissioned that say, is there real public demand for this gas, as opposed to this company just wanting to make the money themselves shipping it along these pipelines instead of paying to ship it on somebody else's pipeline. And we think that there's a pretty strong argument that no, these pipelines have not been shown to be necessary for the public, that this is actually an issue of corporate profits over private property and over, you know, public rights to environmental well-being. So that's the Natural Gas Act. That's primarily the claim we're pushing, that the company has not shown that this actually serves the public convenience and necessity. And a closely related statute to that analysis by FERC is the National Environmental Policy Act, or NEPA. And what that requires is that before making a major decision that could impact the environment, like authorizing one of these pipelines, agencies are required to look at the potential environmental impacts of their decision. How could this affect human communities? How could this affect wildlife? How could this affect forests? And for a project as big as the MVP, that's a huge undertaking because the standards under NEPA are actually pretty stringent. They really require the agency to take what's called a hard look. That's the term that the courts have used, is take a hard look at the impacts of this pipeline. And before making their decision. Now, NEPA doesn't say if there are going to be X amount of impacts, you can't authorize it. All it says is you really have to figure out what these impacts are going to be. You have to share them with the public and take the public's input into account when you're making your decision. Take these environmental impacts into account. And we think, and those impacts are disclosed in what's called an environmental impact statement, or an EIS. And for the MVP, the EIS, FERC's EIS, has just been woefully inadequate. I'm sure all of you all are aware how much information they've just put off and said, well, we can collect this at a later date. You know, a lot of times even after the certificate has been issued, they've put off all this information. And that has to do with impacts on our streams, impacts on our forests, you know, all the way down to cultural impacts. I know Maury has spent a lot of time working with, there was a cultural attachment analysis, which is, you know, it's not just the physical environment, it's the human environment that they're required to assess the impacts to. And that assessment found that, yes, in places like Monroe County, where the land and the connection to the land over a long period of time is so central to people's existence here, that yes, you have to consider the very real impacts that bringing a major industrial project through that area would entail. And so we have submitted comments highlighting a lot of areas where we feel their analysis has been incredibly short of what's required by the law. And as a lot of you probably know, their final environmental impact statement is scheduled to come out in late June. And we will be looking at that and potentially submitting additional comments based on all of the information that was submitted after the draft environmental impact statement was released. So that's one of the other main environmental laws that we'll be operating under. And the last primary one of those, Tammy will talk about Forest Service regulations. There's also the Endangered Species Act, that's another important consideration. But the other main one we have been working under is the Clean Water Act. And so FERC and the Natural Gas Act preempts most state regulation, except it specifically carves out regulation under the Clean Air Act, the Coastal Zone Management Act, which isn't relevant to this area, and the Clean Water Act. And so the states still have some power under that. And what they are required to do is determine whether this project is going to cause a violation of water quality standards, which those are kind of the minimum levels we set in our streams, rivers, and lakes to say, if you're going to support fishing, if you're going to support drinking water, you know, your pollution levels can't be any higher than this. And so the state, before any federal major federal license is issued that's going to have Clean Water Act impacts, they have an opportunity to say yay or nay. You know, they have an opportunity to say, we don't think this is going to comply with water quality standards, and thus it can't go through. And that's called a Section 401 water quality certification. Now, West Virginia went ahead, and we think very prematurely, and already gave that certification. Yeah. Even while all this information was missing, they said, yeah, we think it's fine as long as you provide all these things. At some point, we're going to trust that everything's going to be okay. And now when that happened, a number of folks in here participated and signed on to requesting a hearing from the West Virginia DEP on that decision. You know, we said the secretary has the authority, if they want to hold kind of a trial type hearing on that decision. And just yesterday, we got the response that they have denied that hearing request. So that came in yesterday afternoon. So they will not be holding a hearing on that, which means that their certification is final. Now, what that allows us to do is go into federal court to challenge that certification, which normally you can't do, but you would have to challenge that in state court. And what we found a lot of times is in the West Virginia state court, challenging energy companies is a very difficult thing. Hopefully it will be less so in federal court, where they're not running campaigns where they have to take donations. So we're hoping for a little bit of a more level playing field there. And so, a final decision hasn't been made on bringing that to court, but I think it's very likely that in the relatively near future, that 401 certification decision for West Virginia will be taken to federal court. I'm running out of time here, so I'm going to try to finish up really quickly. In Virginia, they also have to make the same decision. We had a meeting yesterday with folks in the Virginia DEQ. They are luckily going to send out what they say will be a very detailed information request from the company. I think that hopefully should be a pretty illuminating, at least from how they characterized it to us, as far as the level of detail they're going to be requiring from the company to show how it's going to control erosion on these steep slopes and a lot of these other impacts in karst areas, a lot of these very serious potential water quality threats. So that's a process that will be going on in Virginia over the next 6 months to a year or so. They did tell us they will be having public hearings on those. So when that time comes, I'm sure we'll be trying to turn folks out and speaking with a loud voice at those hearings. So I'm going to step down.
Do you know if this was discussed at that meeting in Douthit State Park 14 days, 12 days ago, between the DEQ and the DEP, where they were getting on the same playing field and discussing how West Virginia reacted to this and what their nomenclature was, and the same was going on with DEQ? Was this, such as this, a strategy to dovetail with West Virginia? Does anybody know about that meeting?
I'm not aware of that, so that's news to me. So I could
Maybe you ought to check it out.
Yeah, it sounds
It
like
was in
something.
Douthit State Park over here, Allegheny County, Virginia. It was either week before last, I believe.
Okay.
Yes.
Well, it certainly seems like Virginia, at least from a process standpoint, is taking it a little more seriously than West Virginia did. We can only hope that they will, from a substantive standpoint, take it more seriously as well. But I'm going to step down here and let others jump up so we don't get too far behind schedule.
Thank you, Ben. And sir, I'm going to catch up with you here afterwards, and I'd love to get that detail on that meeting. We will.
Better be quick.
Yeah, thank you. Thanks a lot. Tammy Belinsky.
Nice to see you all out here tonight. I am Tammy Belinsky. I have a few folks who hired me early on in this process to follow the process through the Forest Service. And although I was never a forester, I've hung out with a lot of foresters. I did work for the Virginia Department of Environmental Quality, and it's no surprise to me that they had a secret meeting at Dallas State Park. So the Forest Service, as many of you all know, are required to amend the forest plan in order to, the Jefferson National Forest Plan, in order to accommodate the MVP. And they have 4 actions. One of them is what they call a plan level amendment. The other are amendments just to allow this project to go forward. Then, because of a quirk in the law, it's the Bureau of Land Management and not the Forest Service who will make the decision to grant the right-of-way, but the Forest Service would need to concur in that decision. If the Forest Service or the other land agency, which is the Corps of Engineers, and nobody's even following what they think about the pipeline crossing their land, because we think that they'll just let it happen. If there is a disagreement between those two agencies, then the decision is elevated to the Secretary of the Interior. So both of those processes, when they get to the end of their processes, have an administrative process at the end where you can, before you get to go to court. So their processes take a little longer to get through than the FERC process, not counting the tolling order. So the tolling order is the wild card in all of this. And I know that Appleman is working hard to set it up so we can maneuver around that problem. So the, in my watching what the Forest Service is doing, they've been very cautious about hinting at whether they would approve it or not. What they're doing is they're making sure that they have all of the information. And like everybody knows, the DEIS never should have been published because it was incomplete, but yet they're continuing to gather information. But I have to tell you, when I read what the Forest Service is writing back to MVP, that it's helping them get themselves ready to build a pipeline. It's not critical, it's not a lot of, some of it's critical, but a lot of it is helping them draft their plans to move forward. That's what it looks like to me. I would be shocked, I would be very pleased, but I would be shocked if the Forest Service didn't amend the plan to facilitate the project, and I'd be shocked if the BLM didn't grant right away. That said, Bert mentioned the 500-foot corridor. I don't think that they will do that. I don't think they will create a 500-foot corridor. They'll amend the plan to accommodate a utility corridor in the path that MVP wants to follow and has proposed, but I don't think they'll make it 500 feet wide. I don't think they'll do that because they actually didn't analyze a 500-foot wide corridor. They've only analyzed MVP's raft. And Joby Tim has made enough side comments to suggest that they're still thinking about whether or not a 500-foot corridor is a good idea. So they don't have to make it a 500-foot corridor in order to accommodate the MVP. They just need to make it wide enough for the MVP.
So they're aiding and abetting EQT in their responses. Is that what you say?
Well, in a lot of cases, they are helping them write their, like, for example, I just read the submittal on their plan of development, which is part of how they propose to control sediment.
I mean, if you want to do this, you got to do that.
Yes, yes. That's the substance of their response. Unless it's something that the Forest Service has asked for and they haven't provided, then the Forest Service is saying, we've asked for this and you haven't given it to us. There's still a possibility that if MVP doesn't provide everything the Forest Service has asked for, that they will reject it. But so far, it appears that MVP is, the visual impacts assessment was submitted last week. And I have to defer a lot to the Appalachian Trail on that, and I'll get some help from the Wilderness Society too. But it looks like a big improvement from what they had tried to submit a couple of months ago. It looks like they actually hired a professional to me. I don't know the substance of it yet, but it looks like MVP has cleaned up its act a little bit. So that's my. Well, it means that they weren't really, I mean, the Forest Service was really having some trouble getting out of MVP what they really needed from MVP. And MVP seemed to be trying to do it themselves, and it looks to me like they've contracted a few things out to some professionals.
So what did the Forest Service say? Let me help you out?
By reading what the Forest Service filed yesterday, that's what it looks like to me. That's how I read it. That's how I read it. So,
I really do appreciate your questions, sir, but if we all could, if we're able to pull those questions and remember them until we're finished with speakers, we really appreciate it so that the speakers actually can deliver to you the information they.
Well, it wasn't clear to me what she was saying. Get straight to the bottom line here. We're not playing games.
okay, well, the other thing, Ben did a really good job of describing the NEPA obligations, and I'm going to maintain that the Forest Service has its own obligations under NEPA, and that they're doing a dance and playing a little bit of a game here with the process. And for example, there's been some, and many of you in the room know that there's been comments made about the inadequacy of the analysis of an alternative called Hybrid 1A that would avoid the two wilderness areas, the roadless area, the old growth area, the endangered species, and on and on and on and on and on. Two endangered species it would avoid by using alternative 1A. And the Forest Service their posture to me was that they didn't think they had the authority to require that analysis on their own. But I told them that I thought I could convince a judge otherwise. So that's one of the issues that will be challenging. The other thing that the Forest Service hasn't done yet, it remains to be seen whether it's in the FEIS, and we'll be addressing this too when the FEIS comes out, is their obligations under their own planning rules. They seem to have gone through this whole process without the recognition that they have their own rules to follow for amending a forest plan. They've been following NEPA, they've been jumping through FERC's NEPA hoops, but they have ignored their own forest planning regulations. And I think it's even going to be too late process-wise. They'll have, even if they address them in the FEIS, I think that they're going to have problems under the law on the public participation level, because it wasn't the plan amendment, the planning regs weren't addressed in the DEIS. They didn't even mention them. So that's about it. I guess I'll yield the rest of my time, which is about a minute, to the next speaker, unless there are any other questions at the end of the meeting. Thank you.
We're trial lawyers. We're used to being at the level of the rest of the people in the courtroom.
Except the
Welcome.
judge.
Except the judge. That's right. Sometimes they come there. And it's good when they come there. I want to thank you all for having me here. Thank Bert and Ellen and Laurie and Susan. I hope I didn't miss anybody, Nancy. My name is Chuck Lawler. I'm an eminent domain attorney. Been doing this property rights litigation since 1976 when I was in law school. And to my right is Joe Stevens from Hamlin, Lincoln County. He's been doing it longer than I have.
About the same time. Not as much.
And to his right is his nephew, Jackie Stevens. They practice together. My firm is Lawler Law, and they're Stevens Law Firm. And we're working together to represent people like you in West Virginia. I think there may be some Virginians here. In the event, we're going to say if, because it's not a certainty that the Mountain Valley Pipeline gets a certificate of public convenience and necessity, which gives him, under the Natural Gas Act, the power of eminent domain. And that's, and only then will they be able to acquire your property without your permission? And that's the bottom line. There's been a lot of rumors about what's been said and what the pipeline can do and what they can't do. Now, on the survey issue, which is what we call the pre-certificate issue, they have been going in and surveying property throughout West Virginia, Virginia, and North Carolina. And there's been some pushback in certain places, none whatsoever in other places. If it doesn't come up, if you don't push back, if you give them permission, they're going to run through your property, and sometimes you don't even know it when they show up. So the first thing you do, and most of, I think, you people in this room have done, is deny permission to survey. And fortunately, your Supreme Court in West Virginia, at least, had the wisdom to apply the statute to the law and the whole concept of public use and say, this is not a public use for West Virginians. It has no connection to us. It's a one-way toll corridor going to somewhere towards the coast. It ends up, this particular pipeline ends up in near Danville, Virginia, and connects with another Transco line. And everybody is speculating as to where the gas will ultimately end up. You won't know because they're making the money getting it from point A, the Marcellus Shale and the Utica and the other sources where they're fracking, to, in this case, the project end is Pennsylvania County, Virginia. And they're going to be charging a lot of money to get that gas there under a lot of pressure. And that's where you all come in as property owners. You happen to be an involuntary partner in this project. In other words, you don't have any say in it if they get their certificate, sadly. And the law really does need to be rethought from the days when we brought over the whole concept of eminent domain. There was a time in English common law when the king owned everything, but then the Magna Carta was signed, and that changed everything. And since then, our country has really, property has been the guardian of every other individual right, and there's been a lot written on that, a lot written about it. So when it comes to taking your property without your permission in this process, it's hard to swallow, without a doubt. The number one thing I want you to take away from this meeting is you're not alone, and you can't do this alone. You cannot go through this process alone. There are attorneys in this room, there are attorneys out there that can help you. We all, the attorneys that represent property owners in eminent domain proceedings pretty much work the same way. We're not on the clock. It's going to depend on the amount that we can achieve for you over and above their offer, their written offer, they being the pipeline, if it comes to that. And quite frankly, people that are signing these easements early now, from now until they get the certificate, they're the ones that really should be here tonight. And I know you all are not, and that's why you're here. Everyone that's going to be facing eminent domain needs to hire an attorney, an eminent domain attorney, and because it's a complicated process and the easements are extremely broad and extremely complicated. I've sat them before multiple judges and and attorneys and gotten different opinions from the judges and attorneys about the same document. So if attorneys read it differently and judges read it differently, you can imagine where that leaves you. You're not going to understand it. You're not going to know what it means. Some of the things it does mean that you may not realize, the language in these documents, it will mean that unless it says gas, which I believe the Mountain Valley form says gas, they can put any substance. In fact, the old Patriot Pipeline, I don't know if anybody was around during the Patriot Pipeline, East Tennessee Natural Gas, which is a subsidiary of Duke Energy, had the easements they acquired both voluntarily and through the court order. The federal court orders read for the transportation of oil, gas, and other petroleum products and any other substance. Any other substance. That could mean nuclear waste. That could mean uranium going to Pennsylvania County or coming out of Pennsylvania, you know, anything. That's the type of, and that's not language, that's broad language, but if the document doesn't say what it's transporting, they're going to take the position that the silence on that subject leaves it open-ended. The same is true about the size of the pipe. The same is true about the number of pipes, other than federal regulations. You get into these regulations, without a doubt, it's a federal project. And once they get the certificate, they're going to be regulated by FERC. But until they get the certificate, they're not regulated at all. I mean, you and I could form a natural gas company and file an application. We could take one, copy it, and file it, and we're right where they are. So until they get the certificate, it's wide open. That's the reason these surveys have been so dangerous. And we talked about it, several of us in Roanoke, about some of the dangers of the information being gathered and then disseminated. That's a potential there that once they come on your property, that information could end up being sold anywhere. And that's not what you bargained for. In fact, you didn't bargain for anything when it came to the survey. They're forcing it upon you. Thank goodness the West Virginia Supreme Court ended that. In Virginia, it's still going on. Isaac and I have appeals pending and other attorneys, and it's a tough fight, tough battle, because the law was stacked against us in 2004 with the Sage case, quite frankly, and then about the same time that opinion came down out of Jack Kaiser's court in Danville, Virginia, we had a statute passed in Virginia, our entry statute. And it's been just a multitude of litigation and a trampling on property rights. So let me get back to the process. If they get the certificate, the next thing they're going to do, my prediction, is file a petition. Now, why would they be in such a hurry to file that petition? Because as soon as they file the petition, and I think they're going to file it in federal court, it would be a blessing to you if they file it in any West Virginia Circuit Court. It isn't going to happen. It's going to be in federal court, and probably in the federal courts here locally, Beckley and some of the others, and they are going to ask for entry to begin construction. Right out of the gate, right out of the gate. They're going to want to go on the property and begin construction, because that's all they want to do. As far as you being compensated, they'll say, well, that can wait. That's after the fact. They'll be required to deposit money to get onto your property. And so one thing, you're now a defendant in a lawsuit in federal court. And two, you've got to make legal arguments. And three, you've got to figure out how much money should be deposited. So you're going to have a lawyer. Absolutely. If they file that suit in federal court, you do not want to be unrepresented. So my recommendation to everyone is to engage an attorney now. It's not costing, you're not saving any money by waiting until that happens. Because if the pipeline doesn't happen at all, I'm not charging you a fee. And I think most of the lawyers in this room would feel the same way. Ask them. That is really what needs to be done to protect your rights. Knowledge is power, and information, and that's what I want to convey to you tonight is that when you get that knowledge, you can stand up to the pipeline and you can stand up to this process. It's a tough battle to keep them off your property for construction purposes based upon the controlling decision in our U.S. Court of Appeals for this circuit, the Fourth Circuit. Our firm litigated that in it's called the Sage case. We're considering having a hearing on that same issue en banc, and it may or may not happen, but I would suggest to you that the law is probably going to stay the way it is. So you're going to be facing a construction crew coming on your property, and things need to be protected in that process. And again, that's where an attorney comes in. As far as the easement's concerned, the easement itself, there are several things that you need to take away from this meeting. One is anything that's unspecified or silent. Silence is bad. Silence is screaming bad because you don't know what the limit is. And easement law is a little different than regular real estate conveyance law. The silence is not a limitation, and therefore they will argue, the holder of the easement, that they have a very broad easement because it wasn't limited. So limits on the number of pipes, the diameter of the pipe, obviously the width of the easement. They're good about that. They'll put the width of the easement. Also the access points. A lot of people don't realize that in every one of these easements they have in the form printed right of access from a public road to the easement swath. And I always say, well, just go down the swath. It hits a public road at some point. Run down that swath, the easement. No, they want to be able to go over your property in a more convenient and less expensive manner. And that's what costs you a lot of problems using your property down the road. That has a negative impact on your property utility and value. So you want to have those easements, we call them blanket easements of ingress and egress, secondary easements. You want to have those specified. You need indemnification by the pipeline. Atlantic Coast has put it in their form. I don't believe Mountain Valley has, but I think they will, they could. And this will indemnify you from any liability, good language if it's written well. So there are a lot of things that come up in this process that you'll need to address. Valuation will be the biggest one in this whole process. How do you value an easement that is just that, an easement? They don't own the land. Well, they pretty much control the land, and it destroys the rest of your land. And that's what we call damages to the remainder. That, quite often, is the biggest component of recoverable damage, of recoverable just compensation, are the damages component to the valuation, the overall valuation. And that's when you get people in to do an impact analysis on the way that the easement, for instance, just use your common sense on this one. If you've got an easement, a gas pipeline, 42 inches with 75 or 50 feet, running within 200 feet of a house on a 1 acre lot, how much do you think that devalues the house right then and there? Any idea? Just guess.
80%.
It could be 80. I agree with him. Some people would say at least 50. I agree there, but it could be 80. You might not have any value for that house, but there's always some remaining value. But the problem is you lose your market. Why do you lose your market? Are you going to buy that house? Are you going to buy that house?
It won't appreciate in value.
Nobody will buy that house, bottom line. And so that's a simple example. Other examples are you get into problems, issues with moving vehicles or anything over the easement swath. They have to be reinforced, and they can do this, and they will. And the technology is much better than it was at Patriot Pipeline in '04. But still, they don't have to, and if you don't get their permission early on in the process, you can't cross that easement with a vehicle. And therefore, if you've got a big tract of land and you want to develop it, you've got a fence down the middle of it, a 75-foot wide fence that you can't cross. It may be okay to look at, and many times they just have the little posts, and then they have pig launchers, which are not as attractive. But the worst thing is what you don't see, and that is the fear. Maybe you do see it in people's eyes, but most of the time you don't. That is the worst factor, and that's really what drives the value. In an industrial area, there's not so much a fear factor, but certainly an inability to use your property, if it was developable, at its highest and best use, which is an appraisal term, in a manner that it would have been before the easement was acquired. So you put all that together, you do an impact analysis, and you put on a case. You basically put on a show. You present a trial, and the attorney is basically the conductor of the show, so to speak, whether an appraiser or an engineer, a real estate developer, a broker, whatever it takes to put on that case about how much that property was devalued in the eminent domain process by the taking, by virtue of the taking. That's the pretty much it. Insofar as the what to do with your property up until the suit is filed, maintain it just like you've always maintained it. The last thing you want to do is let your property get run down, not keep it up. I tell people, do whatever you were planning on doing. With road projects, they're on again, off again. This project hadn't even got the green light to go. So you should not change your life as far as your plans with your property. They'll have to compensate you for whatever you do, because it's your property and your life, and they have no power to change it at this time. Thank you.
Oh, Chris, your turn here in a second. You know, I wanted to follow up on a couple points that Chuck made, just in layman's terms, and based on an article that Chuck had given me a year or so ago, and re-emphasize for the landowner that, you know, a couple of the points that came out of this article is that, you know, one of the things Chuck mentioned was the things that can run through the pipe. My understanding is that, you know, if you're agreeing to an easement now without consultation of an attorney, and it's not real clear, you know, that limitations are on what can run through the pipe, as in only natural gas, the pipeline could at any later time put something that the government wouldn't allow. Right? And am I right on that? Okay.
Yeah.
So where the government today wouldn't allow it, you're agreeing, you know, your agreement is selling that right to the pipeline company.
Yeah, and there's, when I've heard the argument by Dominion attorneys, by McGuire Woods, who represents Dominion in the Atlantic pipeline, I think Wade Massey would certainly make that argument, that if they negotiate with you and get an easement signed voluntarily, then they can get a whole lot more rights than FERC would ever get. They can get it because it's a negotiation. It's a contract that's bargained.
Right, which is sacred.
What they're authorized to take through eminent domain is specifically limited by what FERC authorizes. So,
But not what they're handing people now.
but now what they're asking for you to give them presents right now, and you are under no obligation to do that.
And so thank y'all. And the second thing that became clear to me, you know, in thinking about this from the layperson's perspective is that, you know, if you're not having an attorney help you shave down the provisions and really specifically limit the provisions, then, you know, what's not there is what can happen. And that's counterintuitive to what we learn in English class through elementary school. What's there in plain English. And it's also different from contract, original contract, you know, basic contract law. It's the opposite. It's really counterintuitive. And finally, what you think is reasonable now, what seems to be in plain English and what you're reading in the contract, in the easement contract, that's not the way a contract judge would determine that 10 or 20 years from now. If there's a dispute on that contract, they're going to judge what's reasonable for this easement at the time you're in a dispute. Is that right? That's the way that's judged at a later time. So the question, you know, launched into the next generation is what's reasonable to the judge looking at it then, not what's reasonable to the landowner today.
Yeah, and I had, you read in my article, I have an article I published in the Virginia State Bar about a case that happened with Dominion, Virginia Power, and it was overhead power lines, but the same law applies, and that is they got in that case, a 100-foot easement, maybe it was 150, for a 500 kV line, and it just said 150-foot wide easement for it didn't even say 500 kV line, so they took the position, they weren't limited by that. But Ben's right, you go, in that case, it was the State Corporation Commission, not FERC, because it was an intrastate line, and we don't have a federal agency with electric power transmission. So we said, well, you're limited to the 500 kV, that's what your certificate said. And they said, well, it doesn't say one easement, one line of towers. So this is what they did. They took down the big center, what I call a stick man or lattice tower, which was about 100 foot high, ugly enough. And they moved the one line, they put one line with 160-foot monopoles on one side of that 150-foot, and then they put another line of 160-foot monopoles for the other line. Instead of maintaining the spacing required by the federal regulators for power lines horizontally, they went that way. They just moved the spacing that way, and then they had two lines running down that easement, 150-foot easement, with 1 million volts, and all based upon an easement acquired in 1976, 20-some years early.
So the moral of this story is, if you have to look into easements and negotiate an easement, to get the consult of an attorney expert in this field is going to help you so much in the long run. Ms. Johns.
I want to say one thing. This is a big-ass pipeline. Even in Texas, this is huge. You might be wondering, why is a guy from Texas coming to West Virginia and Virginia to talk about pipelines? His family connections. My brother works with AppleMad, and I want to be clear, there's no relationship between my firm and Bailey Glasser and AppleMad, but the folks at AppleMad have been representing a lot of people on the ACP, maybe a lot of you on the MVP as well, and they recognize that, like any smart person, you got to think about, well, let's win, but what happens if we don't win this battle? What comes next? And I'm here largely to talk about what might come next. So let's do this. Okay. Is this on? Little town called Buchanan, West Virginia, which is on the path of the ACP and is close to where the MVP starts. I don't know if we can see this. See this at all? Okay, so I'm from Upshur County. And does anybody recognize what this comes from? This is from the Fifth Amendment. It's called the Takings Clause. It says, nor shall private property be taken for public use without just compensation. So we've been talking about, Ben was talking about public use, and a component of public use is that there actually needs to be a public need for it, and AppleMad is challenging that in front of FERC, and it sounds like there are going to be some challenges in court too about whether this pipeline is really a public use. So we've talked about that. I'm going to talk about just compensation as well. Those are the two real big limitations on the government and those that act with the government's power, like MVP is doing with this pipeline. It's got to be for public use, and they've got to provide just compensation. And probably won't be able to read this, but I love the information that Mountain Valley is putting out. Has anybody gone onto the website and read what they explain? Look, this is one of my favorites. They say, how many serious safety incidents take place on interstate pipelines? We understand the concerns about safety and this and that. Do you know what? They never actually give you a number. They never say how many incidents actually happen on, safety incidents happen on interstate pipelines. And I'm guessing, who's dealt with landmen so far, or property acquisition agents? Yeah. Well, those are like the best folks out there. They're nice people, I'm guessing, most of them. Are they? I mean, I would guess that's the best you're going to get. Because after this, I mean, these are huge companies. They've got, collectively thousands of employees, billions of dollars in assets that are behind this project. And this is who you're dealing with. And as I'm thinking about the Star Wars movie, anybody Star Wars fan here? Good. You know how Luke, he goes in at the very end of the original first movie. It's always so confusing to talk about Star Wars, but the original one that came out in the 70s, and he goes in and he's flying his fighter and he shoots, and it goes perfectly down this little tunnel and blows up the Death Star. I mean, that's what we're hoping happens with AppleMad, right? With AppleMad, and also with the political stuff that's happening in Virginia. If you had a governor who refused to sign the 401 certification, then that, to me, those are really the only two shots that you have of blowing up the Death Star. Otherwise, it's coming. And I think anybody that cares about your interests is going to tell you this. It's a bit of a long shot to blow that up. It's wonderful work that these guys are doing, and we should have a lot of hope in them, and we should have a lot of hope in our political processes to elect people who aren't going to let this kind of stuff happen. But we need to be the agents of change on that side, and then we need to really pray hard for the AppleMad folks. So if the Death Star doesn't get blown up, this is what you're dealing with. You're going to deal with a lot of attorneys from MVP. Well, maybe not this many, but there is something similar about the stormtroopers with what you're going to see from the MVP lawyers. They tend to have a few basic, predictable moves. And I'm going to talk about some of the things that they tend to do. They're going to say they're going to pay, once they get you in court, right now they may offer money to folks for the easements. We'll talk about easement terms in a minute. But they're going to offer to take the part taken, but they're going to largely ignore the real impacts that this pipeline is going to have on the remainder of your property. And Chuck did a wonderful job talking about damages to the remainder, or sometimes you'll hear the term severance damages, and I just want to explain what that is. So, if the gray is the easement, we sometimes call that the part taken, and then everything else that is your property is called the remainder. That's the land that's left over. And so when you hear those terms thrown around, that's what we're talking about. And on the easement, the part taken, a lot of times they're going to say, well, we'll pay you 80 or maybe even 90% of what the value of your part taken is. So for that acre, let's say, that they take, if that's worth $10,000 an acre, we'll pay you $9,000 for it. And you'd think, well, gosh, why are you not just paying me for the whole thing? And their argument is, well, you can still have a picnic out there. Yeah, it might not have a tree. It might not have those trees either. We might get rid of your bridge, and we might put a sign up there, but you could still have a picnic out there, so you have some use of your property. It's still yours. You still possess it. It's still yours in air quotes, right? But That's the idea, the concept that they're going to pay you for the part taken. But what they're going to ignore is the remainder. And I want to talk about a case we had where the pipeline company, what they offered was $79,000 and change, and they said, you know, this is, our client's property was on kind of the southwest side of those highways there, but it was a great place where two highways came together. It wasn't developed, but it was right on the edge of development of this town. And the pipeline went, it's that dotted yellow line that goes through there. And our argument was, well, gosh, yeah, you might have only taken a few acres of this much, much larger tract, but you took some of our, you took it right along the frontage. And the front acreage is worth a lot more than the back acreage is. And any chance that we had to develop this thing, out the window, because if a developer comes along, and we actually in front of the jury, we got a 14-foot 2x4 that we were able to take into the court, because that's how deep we would have needed to have put any utility crossings that we wanted. That's what the pipeline company wanted us to do, was to make our clients dig 14 feet under the ground so that it would not interfere at all with their pipeline. So this is one thing you learn about easement terms. It's important to get your easement terms right. And for some of our clients, we have documents where there's negotiating power. We sometimes have really extensive easement terms that are pretty onerous for the pipeline company. So I just want to talk real quickly about some of the easement terms I hear from, no, it's fine, that I hear from pipeline clients. They say that and looking at the easements that are thrown in front of them, sometimes the MVP, their stock provision allows them to put additional lines at some predetermined cost. You know, right? They'll give you a certain amount in the future, but we're going to determine what that price is today. And talking about, you know, the idea that what might look good today is not going to look so good tomorrow. I've got a client right now who is dealing with an easement from 1964, and he allowed them to put multiple lines on this easement. And then, do you know the rate he negotiated per foot? $1. $1 per foot. So that's what if we're not able to convince a judge that one pipeline needs to be right next to the other one because the pipeline company has decided to cut right through the middle of his property rather than go where the existing pipeline was, if we don't convince the judge of that, then this guy's going to get not very much money at all, you know, $1 a foot. The other thing they'll do is they'll say, hey, let us put in some above ground structures, you know, cathodic protection, valves, launchers, whatever. Well, you can guarantee that if they haven't gotten those kinds of terms from other people, if you've just given them those terms, you've just become a magnet for above ground structures. Roads. Okay, sometimes they're asking for, if you build a future road, then you would give them access to the future road that you build. If a line's replaced, no additional compensation for installation of a larger line. We've kind of talked about that. So right now it's 42 inches. There are bigger, believe it or not, there are bigger gas pipelines. And then a prepaid damages release. So the idea there is that they're putting in a damages, you're releasing them from damages, and the landman will tell you, oh, this is so that if the trees grow back up again and you're saying, gosh, I really want my timber, they'll say, well, we already paid you for that. But by putting in a release of liability, you might be giving them a release of liability from all kinds of things. Say a worker gets hurt out there and they're on your property. Are they going to be able to sue you? Maybe. If you give them a release, perhaps the person sues you and you don't have any kind of indemnification, any kind of protection from MVP to take care of the problems, any kind of insurance to cover what's going on out there. So it's really, really critical. I think there are two things to really be careful about as a landowner. One is the easement terms. but the second is the just compensation. But just compensation is absolutely critical, and we'll talk a little bit more about that. But easement terms, that can make the difference between you staying on the land or not. It can make the difference in whether you're going to be able to get any kind of value when you sell it later on. And there could be a lot of things unexpected. So be careful with that. Okay. Oh yeah, so in that case, our original offer was $79,979. We ended up getting a jury verdict of a little over $1.6 million. So there can be huge differences of opinion just based on remainder damages. You know, everybody agreed that $79,000, yeah, that was probably about right for the part taken, but for the impact on the rest of the property, it was massive. That the difference there is mostly remainder damages. Okay, I'm gonna skip this one, or at least go through it quickly. A lot of times they'll try to put the focus on the wrong thing. And that happened in one of our cases where we had a large a manufacturing facility. And I know that a lot of folks won't have this, but I hope this, you might not have a 700,000 square foot facility on your property. But this still proves the point. The state took, in this case, less than 1/10 of an acre. And that's what they wanted everybody to focus on. That's what they asked the court to focus on. But we pointed out, wait a second, you've also denied access to one of the entrances to this plant. And that caused a lot of damage because our clients had to completely reconfigure how the trucks would come into the plant and where things would be spit out on the other end. $7 million, that's what we settled for, just under that amount. So their original offer is about $1,400. Okay, they might compare your land to land that's not similar. In this, I am gonna skip this one. We have except to say, we have a case ongoing right now where this is a beautiful, it's right next to a national wildlife refuge. It has whooping cranes, all kinds of endangered species that come through here, trumpeter swans, just beautiful, beautiful place. And it has a reservoir system that took years and years and years to build. And when they came in to value our land and what a pipeline would cause as far as damage, and let me say one thing, there was a question from the landowners in advance, well, what if it would be more convenient for me to have them go through another part of my property? Pipeline companies, they don't care. They didn't care in this case, and I know that that's their MO. In this case, they could have totally avoided this whole water thing and gone on another piece of our client's property and done very little damage. Instead, they cut through our reservoir system and are going right over the canal where we bring all the water in because the client has a lot of water rights. And so, do you know what they compared this to? 6 pieces of property with 0 water features. Yep. So, a few points. When you have a pipeline come through your property, you've just gotten a development partner. If you want to develop your land for anything, you got to get your partner's consent now. If you want to cross their easement at all, with utilities, with a road, anything like that, you just inherited, not by your choice, but you just got a development partner. We talked about reductions in value. We've talked about, other folks have talked about environmental and safety risks. So now let's quickly talk about the process. It's confusing. I mean, even for lawyers who have gone to law school, have taken property law classes, this is different from a regular class. I mean, this is a completely different process. There's in federal court, the judges get to decide who gets to hear your case. Is it a jury? Usually in state court, you get the right to a jury. Not in federal court. A judge gets to decide whether to give you a jury or whether to give you what they call a tribunal, or whether the judge, him or herself, will decide. Another thing is that you've got to assert your legal objections and defenses in your answer. A lot of them have to be asserted in your answer. I mean, you don't have to figure out what the value of your property is when you first file, but I would say it's really important to, as Chuck said, to go ahead and get a lawyer right now, because there might be things that you could be doing right now as far as planning to kind of play the game a little bit, because it is a game. It's certainly a game to them on how they're going to maneuver things in order to minimize how much they have to pay to you. So it's important to get with somebody right now. It's tricky. It doesn't, so just compensation under the Constitution doesn't include your sentimental attachment to the property. It does not include your attorney's fees. It doesn't include the litigation. It doesn't include most litigation expenses that you'll have. So it's really, we call it just compensation, but courts, it's not completely just. It's not fair to the landowners. And in part because most of us, if we're ever hit with a condemnation case, it happens one time. Where on the other side, these pipeline companies, the states, the municipalities, they're repeat players. And so they're constantly trying to whittle away our rights. And they've convinced courts to do it over time. So, you know, what you're given is the difference between the market value of your property before it was taken versus how much it's worth after, now that the pipeline's in, these property rights have been given to the pipeline company. But it's not as simple as that, because sometimes courts say, well, you know, there are these carve-outs. Noise, in some cases, you don't get. They'll say, even if market participants would pay less because they're worried about the noise from a project, we're not going to allow you to recover for noise, the diminution in value due to noise, or, you know, kind of generalized pollution, or certain denials of access, or construction aggravation, or your business lost profits. You know, so it's not as simple as you might think. You need somebody that can walk you through that process, and part of that is putting together the right team. Chuck talked about it. You've got to get a good appraiser. Not just an appraiser that does a refinance for your bank. These are specialized appraisers who are used to testifying in court and who can defend their opinions. Yeah, you need Obi-Wan, you know? You need Yoda. You need somebody that has been through the process before. And that would be the biggest takeaway that I'd want you to have, is that whether you hire, you know, me and Bailey Glasser, or whether you hire Joe and or Chuck and his team, hire somebody that has done it before, somebody that's gotten results for landowners, because without that, it's going to be a very long and frustrating process no matter what. But you at least have a chance, you have a hope of getting a result that's positive in some way, getting just compensation, getting the easement terms that are critical. So, you know, with that, I just want to say one more thing. This quote from Margaret Mead. She says, "Never doubt that a small group of thoughtful, committed citizens can change the world. Indeed, it's the only thing that ever has." I really admire all of you for sticking together.
Thanks so much, Chris. Thank you all very much. I wanted to lead in with a couple of, a couple basic questions. Oh, thank you. Yes, please. A couple questions framed by Summers and Monroe County leaders. If y'all would, just take a moment and just, lead in here if you think you'd like to discuss this. I know, Chris, you have.
Do you want us to sit here, or
Sure. If y'all want to come on up, that's very helpful. Thanks a lot. Yeah. Chris, we discussed this yesterday. On the issue of compensation, who decides, depending on, what court you're in? How is that decision made? And
Yeah, so it's very likely you'll be, as Chuck mentioned, very likely you'll be in federal court. If you're in federal court, the rules are that the judge gets to decide, and there are three options that we kind of went over. The judge could decide the issue of just compensation. A tribunal could decide, and then a jury. You could ask for a jury. I would definitely ask for a jury every time, because I feel like, you know, the commissioners, people on the tribunal, many times they tend to be on case after case after case, and even though they're supposed to take a fresh look at every single case, they know what's happened in other cases with less than competent attorneys in other cases. And I think sometimes it's really bad for you not to get just a completely fresh jury that doesn't have those kind of preconceived ideas about what the property values are and what the damages might be.
Joe, you know.
Well, I'll put it this way. I'm a country lawyer from Amarillo, West Virginia. I'm a native West Virginian. If they're going to take away my life or my liberty, give me a jury. If I were representing anybody in a condemnation case, I'd fight to the end to get that jury.
And it is the judge's decision, but I can tell you, I know the judges in Virginia. Joe would know the judges in West Virginia, Joe and Jackie. The judges in Virginia will not deny a property owner a jury trial. That would be, even though they're impolite, I think they realize they're not going to do it. They're not going to go there. And the judges in the Patriot Pipeline, which was our last big gas pipeline in Virginia, granted jury trial. So it'll be a jury trial if you ask.
Well, and I'll tell you a good reason why. My brother, my former law partner, was judge of the Circuit Court of Lincoln and Boone counties, and I got the inside perspective directly from him. Why does a judge want to take it upon himself to make an important decision like that when that judge can have a jury do it? So I think your chances of having a jury would be a good one, but it's something that you want. You're guaranteed your day in court as an American citizen. And so that's a very important point for you to remember when you are approached by this pipeline company. Ultimately, if you have to give up your property, you want a jury to decide what it's worth to you.
And there's actually an appeal going on right now in the Sixth Circuit from Michigan, where they're actually challenging some old law, some old interpretations, saying that they're trying to assert that you actually have a constitutional right to a trial by jury in a takings case. So we'll see how that goes. But I'd say you definitely want a jury. You'd want to ask for it for sure.
Well, what's your prognosis, Professor?
On that one,
Yeah,
I think it's possible.
yeah.
Yeah.
Okay, good. That's encouraging. Can you forecast a little bit how long it might be from the time of any potential certification to the time the eminent domain process would hurtle into effect against landowners?
I think it could be almost immediate.
It could be. And what would that depend on?
That's just the decision of the pipeline company.
Well, I can tell you this much. When you compare state court lawsuits to federal lawsuits, as a lawyer who has never been a corporate lawyer, who's represented the person on the street, like I believe this crowd is, regular West Virginians I call them, if you are in state court versus federal court, your federal court will probably make it to trial quicker than a state court in many times, depending on who the judge is. So you can pretty much depend that if this is done in federal court, it's going to get on a fast track once it makes it to the point that they file a condemnation suit against you.
But is your question from the issuance of the FERC certificate to the filing of a complaint? I think that's very fast.
It can be. I'll say, in other pipelines we've been working on, we've seen some that come right after the certificate is issued, and then we've had certificates that have been out for 6 months now, and there's still landowners who haven't had a complaint filed against them. So I think it depends to where they focus their resources, where they're looking to build first, all kinds of things like that. But it could be immediate, it could be as soon as the next day.
That's true of linear projects. You got to understand, this is Mohawk Valley's 300 and some miles. And there are certain places along that path that they can start construction. They've already gotten many easements, they say. We don't know how many. You could look them all up in the county courthouses, but they can certainly start wherever they've already acquired an easement. And then those, I would suggest to you, if you're near those, that they've already acquired a lot of easements in, you're probably going to get filed early. If you're somewhere where they really don't need to get to you till the end, they'll wait.
Thank you, thanks.
Well, let me make another comment here. If the action is in state court, it may be a little bit different. And by the way, I'm a veteran trial lawyer handling condemnation cases, both in federal and state court, but primarily in state court. But in West Virginia state court, the condemnor, in this case the pipeline, has to pay into court an amount that they contend is reasonable compensation for the taking. But thereafter, we would hopefully have a jury that would determine the real and final figure. But you can't apply to the judge to have those funds released. And so you could take part of those funds during the trial process, you see. So there is something to work with, at least in state court.
That's the same way it works in federal,
It's the same way.
in state and federal court. They deposit a sum of money and you can actually request more. And then there can be a hearing on that. You can fight over the amount of money that they deposited early. But as Joe said, that can be drawn down and there's no benefit by letting it sit there. Sometimes in non-interest bearing funds. Now, if it's $10,000, that's one thing. If it's $200,000, that's another. And you at least want interest.
And let me, another comment, while we're along this line. You know,
Yeah, no,
what
I
is
really appreciate
what
it.
is the value, if you're trying a case where they've taken your client's property, what's the issue for the jury? Well, the jury is, what is fair compensation? And underlying that issue is what is the proper use for the property? Well, we've heard a little discussion that we've seen the illustration on the screen about a commercial use of property. In the real property appraiser's world, the most valuable property in its highest and best use is commercial property. A commercial piece of land at an intersection on a major highway is worth far more than a residential house at the same place, because they can make more money out of it if it's taken in the line, if it's sold to McDonald's, for instance. And so that would be an issue that you would want to fight hard to demonstrate that perhaps your property has some commercial use. If you have a properly trained, good appraiser who has experience in the courtroom and who can defend their opinion about this, then they're going to examine things like, what category could this land be used for? And that's a jury question. That's a question for a jury to decide. Maybe some or part of your property could have a commercial use. And these are part of the intricacies in preparing your case for a decision by a jury or even the court.
Thank you. Really appreciate those answers. And so, again, folks from Summers and Monroe ask, what does the landowner's initial response need to include? In other words, what sort of homework should a landowner be doing now? You know, in potentially, you know, if MVP has their way, they say September. We're hoping that's not the case, but in the worst case scenario, if we're looking at a September certification, what should the landowner be doing right now?
I'll venture an answer on that one. That is hire an experienced attorney who's handling condemnation cases, because they got plenty of it. That is the pipeline company does. You can bet on that. So that would be the number one step, in my opinion. You have to pardon me, but I firmly believe.
Hire an attorney that does condemnation work.
Right. I mean,
Shocker
that's
that
your
we would
number
say
one
that,
step.
right?
Exactly, but it's the truth.
Okay, so then bouncing off that, Chris, You know, let's say my neighbor Marie is terrified of courts and really, you know, doesn't like most lawyers she ever ran into because of her horrible experience in the courts. And she shows up with a certificate, at certification, you know, and it's court time. She wants the eminent domain trial, but she doesn't have an attorney. If she's put that decision off, my question comes from this. Our friend Carolyn Elephant, who practices, you know, FERC practice and a variety of practices related to pipeline work, you know, commented that, you know, it was remarkable to her the number of people who would fight pipelines and hold out, and they were not represented, and they, you know, there still were, you know, potentially appeals going on, but she was shocked at how quickly people signed easements after certification, even though they had fought it so far along, if they were unrepresented. So that's my question. What happens, you know, when you have to go see the judge? I mean, is that a realistic question? Does that not happen? If you're at certification and
you haven't hired an attorney?
Do you ever,
I mean,
have you ever run into a judge who will give you guidance on this matter? I mean,
Well, most judges will try to look out for a pro se litigant. The first thing they say is, hire an attorney. You're in trouble, hire an attorney. They'll say it multiple times. And if the pro se litigant, the person unrepresented, doesn't listen to the judge, they'll schedule a hearing. Unfortunately, it's ugly.
they'll schedule a hearing.
They'll schedule
Yeah.
a trial.
Yeah, they'll schedule a trial. Okay.
Right, and there are, it's important to understand that, you know, we put the picture of the labyrinth up here. There's a whole series of things that need to happen in an eminent domain case. You know, a certain date on which you're gonna, you know, say who your expert is. You've got your appraiser. What's that person's opinion? And if a person has just gone out and tried to get some appraiser, one thing I'd question whether any appraiser worth his or her salt would be willing to go with a pro se client and a landowner and try to defend their opinion of value, because even though, you know, we've heard that the landowner's gonna get his or her day in court and all of that, it's not, yes, that's true, but it's incomplete. You need to know the whole truth. They're going to get their day in court, but the day in court's going to go very badly if you don't have a good attorney team and you don't have a good expert team, you know, which could be a combination of appraisers, land use people, you know, real estate professionals. So, yeah, they'll get their day in court. It's just going to be ugly.
So following up on that, then, I guess what I want to say to you folks is, you know, you may or may not, be 3 months down the road with these attorneys' numbers. If you have phone numbers and contacts, if you have neighbors who are you know, awash without counsel, you can be in touch with Nancy, Susan, Lori Artisan, myself, Ellen Darden, Bonnie Law. Bonnie Law from Franklin County, came all the way from Franklin County, Virginia. After giving the devil to the Board of Supervisors there today, I hear. And so, you know, we'll leave you with our contacts, and that's been our work, is putting folks in touch with, you know, people who can give them correct answers throughout these many months.
Well, could I say one last thing? Remember that it goes for all of us who are speaking to you. These are the types of cases that you don't have to pay us to retain us. Yeah, do you understand that? We work cases like this on a contingent fee. And so we don't get paid anything unless we can increase the value of what you receive for the taking of your property. You can call us, you can speak with us, you can meet with us. And I hope that's understood. One other thing, on the issue of whether you get an attorney. Well, how important a thing is this in your life? A divorce is a very important thing. I would never recommend that a person get a divorce without counsel, nor would I recommend that they enter a plea of guilty to a crime without talking to a lawyer. Why in the world would you let somebody take your property away and not have an attorney? Because after all, you know the old adage about the lawyer that represents himself. He has a fool for a client. So think about that. And that applies to lawyers.
Susan, have I gone through the summation of those two major? Could we open it up then? I mean, we have a host of questions that have come in from landowners. I think a lot of it.
Yeah, I'm going to try to circulate as best I can with this so that everybody can hear the
Yes.
questions.
Sure.
And I'm going to ask you one to begin with, guys. One of the pressure tactics that the landsmen have used on people here is if you don't sign on now, you're probably going to get a lot less money later. Can you comment on that?
I've never known that to be true.
I would call it unethical.
That's not true. They should be, that kind of statement should be reported.
Can't hear you.
The rule in Virginia, West Virginia, reporting, one party knows and can report it. And those are the kind of statements that I know. I've got a friend in Raleigh, an attorney whose family farm is being subjected to ACP. And she's got reporters on this, these statements that land agents are making. They're trying to compile a whole list of them, but they need to be proven. And the best way you can prove it is a recording, because that statement is highly improper. It could be illegal. I'm not going to say it is. It's a misrepresentation, but the courts may say, well, he's just puffing. You know?
And it's hard when you're dealing with comments about what's going to happen in the future to bust them for fraud. That's tough, but I've never known that to actually be true. Anybody that's hired us, anybody that's hired other good eminent domain counsel has always gotten more than what they'd originally been offered. Always, 100%. And I'm not saying that as a guarantee going forward. I'm just saying in my experience, our firm has never gotten less for a landowner than what had been offered.
I can agree with that.
Yeah.
In my 40-year career, I agree. I can prove that that's true.
Yeah.
Okay, you said that Virginia has not completed their certification under the Clean Water Act. What is the potential impact for West Virginia if Virginia would deny certification? Could that effectively stop the pipeline because it couldn't get to them?
Yep.
Is there anything we can do to help that?
Well, what I would say you can do to help that, I mean, honestly, the best thing you can do to help that is support Tom Perriello. I mean, and I'm 100% serious about that because the McAuliffe administration is pretty friendly with energy companies, with the natural gas companies. So he's gonna. My impression is he's gonna give it the full process, right? He's gonna jump through all the hoops. He's not gonna have people screaming at him that he didn't, give them the opportunity to speak. But at the end of the day, he's most likely going to let it pass. But so the best thing we can do is to keep badgering them to draw this process out as long as we can, and hopefully Virginia has a new governor. I think short of that, yes, once the comment periods open up, they have said that they told us yesterday that they do to push this project through. That's the kind of thing that can actually make somebody think twice or make somebody think, I'm not sure this is the decision I want on my legacy. Maybe I'll pass it off to the next guy.
I'd add, as a member of our pipeline community, we ought to bring busloads of people to the hearings, from West Virginia to the Virginia hearings, and remind those folks that they will impact people up the street.
Virginia, you're our only hope.
No pressure.
There's been a lot of talk about landowner rights for the land that the pipeline is going through. It's not going through my land, but it's going close to my land. It's obviously going to affect my property values. Do I have any legal recourse for compensation?
Yeah. be interested to hear what these gentlemen say, but I think it's a really hard case. Obviously, if there's actually a spill and it contaminates your land, yes. If it contaminates your water, yes. It's very, very difficult. In West Virginia, there's a cause of action that's prospective nuisance, but the standard that you have to show for that is incredibly high, and I don't think most judges are going to be willing to give that or recognize that kind of an action for somebody who is not actually on the pipeline. And the reason being that a nuisance is an unreasonable interference with somebody's use and enjoyment of their property. And I think a judge is going to say, well, gosh, isn't that what FERC's doing right now? They're deciding whether this thing is reasonable or not. And if FERC says yes, I just think it's a very hard claim that property owners off the easement would have. And it pains me to say that. I think everybody should be compensated for the damage, the reduction in value to your land. But the law just isn't very favorable.
On that same subject, I'm getting ready to make a comment to FERC about that issue, about the 1st of June. I think that, I would hope that somewhere in this world, some attorney will take a class action suit for all those affected adjacent landowners, anybody in the high consequence area. You'll have millions of clients.
Would you guys take that?
That's a lot of work.
We'd have a look.
I'm an affected landowner who goes across my property, and I have some bargaining power, but I've got neighbors who are just as close. It just pains me that somebody hasn't stood up for this.
Well,
Go ahead.
let me say this. The rules that affect the public taking of land, what do you have here? You have a plan for this pipeline drawn up by engineers that says we have to have a right-of-way X number of feet wide. So if you are the property owner, the pipeline company is going to take your land along a definite boundary. Now, what you're talking about is if your land is not adjacent to or a part of the take, then there is no condemnation proceeding that's applicable to damage to your property. And the condemnation proceeding, of course, is a forum to establish what the fair value is that you are entitled to in terms of money damages for taking your property. But adjacent land that's not a part of the project is not a part of the condemnation proceeding. Now, a person might, in theory, be able to prove that the installation of the pipeline has diminished the property values, but you're not going to be able to address that in a condemnation proceeding, as far as I know. And I can see your point. I mean, yeah.
You can file your own inverse condemnation proceeding.
True, yes.
Attorneys that take those cases, and I've taken them, and they're very easy to lose if you don't have really good facts, especially the scenario you have described. The law in Virginia has gotten worse. West Virginia, I don't think it's gotten any better. The point of law here is that there's federal law, and under the Fifth Amendment takings, that if there is a penetration by an agency with the power of eminent domain into an actual invasion or penetration into your land, that's a taking. Now, in this day and time, and it's called a per se taking. That's the Loretta v. Teleprompter case by the U.S. Supreme Court. That gets a little murky when you're talking about gas, and that's the one I'm thinking about, leaking over into your land. Now, if you could prove that, that's an invasion on your property. It's very complicated. It certainly would be a risk on your property to have gas, but usually gas disperses pretty quick, so you're going to have a tough one there. The mere fact, as Joe was indicating, that your property has been reduced in value due to the close proximity is one of the tougher inverse condemnation cases that I think you find in probably any state. The law really, and it's basically this idea, well, where are we going to stop with this? You say you're close. If we get 100 feet away, are you still entitled to damages? If you get 1,000 feet away, you run into the same thing with views. Oh, I don't like that ugly tower. I don't like those pig launchers sticking up out of the ground. Well, how far back do you go with that? the courts are concerned there's no limit to this. It's going to be an open floodgate of litigation, and they don't allow it. They just say, we're going to stop it with the easement line.
And the only thing I'd add, I think that's all right. The only thing I'd add is in certain particular cases, you might have a better inverse condemnation type situation. If you could show that the damage to your property value were 90% or more, perhaps you'd have that person would have a much better case than somebody who says, oh, it's caused me 10% property reduction.
I have a question. Under that eminent domain, if they get it and you don't settle your claim or sign the right-of-way, can they immediately go through your land anyway?
I think Chuck talked about that a little bit, that it's sometimes called quick take. Can they just deposit a certain amount and then immediately get possession of your land? The answer is generally yes. There were some bad cases that happened. What was Sage 2004?
Yeah.
Sage was 2004. There was just another case in the Fourth Circuit that was dealing with the same issue that could potentially go, as Chuck said, en banc, which means the whole Fourth Circuit, not just 3 judges, but everybody on the Fourth Circuit federal court could decide whether to change that rule. But I think there's a good argument under the Natural Gas Act that they shouldn't be able to do that. But so far, the law that controls in federal courts in Virginia and West Virginia is that once they've made that deposit, they can go on and start building the project.
You up the creek anyway you go.
Yeah, hopefully you've got a good oarsman with you.
You've covered the compensation if we don't have to deploy the Death Star, but how likely are we going to be able to negotiate modifications to their contract proposal? Because the one I got a problem with having it in the paragraph.
Well, that varies a lot. It varies a lot on the project manager. It varies with the condemning agency. Mountain Valley is one, Atlantic Coast is another. Here's the pipeline's viewpoint. They don't like a lot of different easements. And we ran into the same thing with electric power line easements. They like to keep things consistent. So they want that broad language that favors them throughout. Because where they get tripped is if they have a special change in the easement and they overlooked it. So they much prefer not changing that form easement. I can tell you, they'll tell you that's a form, they don't vary at all. It can be changed. I guarantee you, if you have enough political power, it would be changed.
Yeah.
But it's a negotiation, and you can't say, they'll say it can't be done, but I think it can on certain things. Other things, you won't get it. You'll have to go to court, and what you're going to get in court, what they're going to get a court order for is the easement that was described in the petition, that was described in the application for the certificate. The type of easement, which is, in your case, 42-inch pipe with 75 feet, maybe permanent, whatever they described in their specs going forward, under the pressure that it's under.
And I would say what the easement they put in front of you right now might look very different from the easement that a court says they're able to get, because FERC is only giving them permission to take this much. They're asking for this much right now.
And we've made that point several times.
Yeah.
That's probably the best reason not to sign that form easement. The best reason is because you're giving them things they can't get in court. You don't even know it, and you are.
And I would add, there are certain minor modifications sometimes that FERC will require them to make if a landowner requests that through the FERC process. That's not always successful, but if you, say request that they move the line 20 to 30 feet either way to avoid a structure on your property or something like that, that's sometimes some things FERC can be receptive to. It's a little late in the process for that, but I wouldn't say it's necessarily too late. So if you can get those changes made in the FERC process, then that's one more point of leverage that you have when you're negotiating compensation, right? That's one less thing that they are authorized to take.
Which is to say, would they write a comment, a
Yes.
specific comment, file a comment? That's right. Okay. And I've seen that happen at least twice in our area.
My property is a working farm and has been since we've owned it since 1949. And one of our enterprises is beef cattle, and they are confined. They're fenced in, and they will have to remove at least 75 feet of that fence. And my question is, how do I contain my cattle if they put a big gap in the fence? Do you, in your experience, have you seen that happen? Whose responsibility is that?
It's theirs, and I've never seen a case where they didn't fix it somehow. Somehow. You
How
won't
will
like
they-
the solution necessarily.
How will they confine my cattle during construction? They'll have to have the fence.
They'll put a-
Sometimes they could have gate guards that would help make sure, I mean, you want to cooperate with them as part of that process and work through your attorneys to figure out exactly the mechanics for your particular situation. But I agree, that's the kind of thing that they tend to work with you.
All right, one other question. We have a family campground on our farm, and there's a water line that that crosses at a 90-degree angle, crosses the proposed MVP line. And they'll have to cut that to install the line. Now,
Maybe,
what?
maybe not. They can trench under it, not likely. They can trench under
So
it.
what
They're
are
doing
my
that under
rights?
rivers and under mountains, but that's very costly. So they will, in all likelihood, cut it and temporarily move it.
One of the main concerns some of us have is our water. And is there anything at all we can do, because a lot of us have springs, and they aren't necessarily on that property, but they could be affected by the other property. Our water issue here is huge. We have cars, and I think that's one of our biggest concerns. What can we do to get attention to that? Our environmental won't even let us have a public meeting. So what can we do?
I'd like to say, a couple things come to mind right here and now. These attorneys have all spoken about the need to, if you are concerned about the particular routing as to your springs, you can file a comment regarding that specific to your property. And if you're not comfortable on the FERC process site, we can get you help on that. And we'll plan for that. Actually, what we have is filing parties in Roanoke County, and you just come over right here and set up shop, and we can tell the neighbors, come on in. It's perfectly fine if the comment is handwritten. We'll get it filed and get you identified to FERC. All that matters in my mind as a landowner advocate. That docket is open. We're filling it with the information we expect FERC to read. There will be an administrative appeals process, and the judge is required to read that information. And if we don't exercise, and I'm going to say it again before the night ends, if we don't exercise the opportunities that we have here to file that information in the FERC docket and use the muscle that we do have, we're going to lose it. Glad to help you with that. The other thing is water testing, and very briefly I'll tell you, we are looking into a water testing program. I think you all have had a very good experience with downstream strategies here. They've helped in some analysis of watersheds already. we're working very closely with them to devise a program that, would be affordable to communities. There is a difference of thought among lawyers as to whether individuals should allow the company with regard to MVP's invitation. And it is an invitation, and they do desperately need to get that information into FERC regarding your watershed. And those are the questions they're asking. It's basically a water survey in disguise. It's also an invitation to get your water tested. Some feel that, in fact, guidance by AppleMed, and I'd encourage you all to expound on this, that having the company test your water is better than nothing. Others feel that's not so. Some among us feel, why? We haven't been able to trust them on anything else they've said. Why would we trust them with our most precious resource? There is at least one case I've read about where a tester has been prosecuted for misstatements and misdealing and fraud in the analysis and reporting of that water. It's terrifying. And so what we are working on right now, and we'll keep you posted as quickly as we can put it together, is a program of affordable testing for everyone. I can't say we're there. I can say we're working as hard and fast as we possibly can get.
Roberta,
And
on this intervening status, there's many interveners here, but there are some people here who have never filed to be an intervener.
okay.
I have done this on behalf of 9 or 10 neighbors in my area. I hope somebody will help me, but if there's anybody here from Monroe or Summers County who has not filed as an intervener and wants to do that, see me. I'm an expert at it. I can do it pretty quickly.
Yeah, and I'll just say, even if you don't file as an intervener, you still can make comments about your property to FERC. If you don't want to go through that formal process, you can still make comments into FERC. And I'll just say something quickly about water testing. So first I will say that I am not, and AppleMed is not a law firm that deals with damages suits, to individual people's property for damages to their water. So really here I'm speaking just as, somebody who's looked at water quality issues a lot and just kind of giving, my informal advice here. I can't give you, I don't think I'm, totally qualified to give you official legal advice about, how to prepare for potential impacts to your water source. But I would say, just as my personal thoughts, if you're able to get independent water testing, so the idea is to establish a baseline, right? Say, what does my water look like when it's good? When it's, the way it's been for many years? What are the levels of various pollutants, sediments and salts and potentially, diesel fuel things are really the potential contaminants that you might see associated with pipeline construction. And so, getting some sort of baseline to then, if you think the pipeline construction has harmed your water, you can then compare it and say, see, it used to be like this. Now, the quality has suffered. If you can get independent testing to do that, I think that's absolutely the best way to go. That kind of takes away any chance that any company shenanigans. Now, if that's not possible, I personally think having the company perform a test is better than not having to give them. And I personally, if I was a landowner, I wouldn't give them any ounce of information that they didn't have a right to. But if they are going to test the water, I think if you videotape them, I personally think that the chance of them really engaging in large-scale fraud on that is pretty small. But they're hard to put anything past them. But that's just my personal opinion on the water testing is videotape them, document them, let them know that somebody's watching, so that if they were inclined to try to pull something, they would be much less so. And having some sort of baseline is better than nothing at all.
And I'm assuming that the public waterways, such as the Greenbrier River, have been tested for a baseline. Is that correct?
Yeah, so larger scale waterways, DEP does somewhat regular monitoring of that. Yeah, and so those are all in what's called the Clean Water Act 303D report. You can look that up online. It has water quality, whether these waters are meeting water quality standards, whether they're not, and all the data underlying that. The DEP has that. Howdy.
The concern that I have with MVP testing your water is that they're going to own the information on your water. It's like them owning your easement if you sign an easement. They're going to have that information, and they're free to do whatever they want with that information. I don't think they're going to have any law. I don't think they're going to fake a result, because I don't think a lab would go out on a limb to fake a result. But having them own the information on my 4 springs, my pond, my wetland, they could sell it to somebody else down the road. So that concerns me more than anything else about them falsifying any test or not, following the chain of custody all the way through.
I hear that concern loud and clear. The one advantage of having them do the testing is that if they've set the baseline and later on you want to use that against them in court, it's kind of hard for them to say, well, who did that testing? Because they did.
Yeah, but if the certificate does not go through, then EQT or MVP still owns the data on my water rights, on my water, on my land.
Yeah, I'd be very reluctant as a landowner to let anybody on my property that wasn't a guest, invited.
Chris,
Welcome.
What Chris or Chuck or any of you guys, what do you think is the likelihood that a landowner would be able to negotiate limitations on what the company could do with that information? To say, yes, I will let you on my property to perform this baseline testing under the conditions that it's only used to determine whether or not your construction has impacted my water quality.
Well, I think they'd consider that, and if they don't let them on.
Well, my consideration would be, if I let them on and try to negotiate, is that an independent lab has to come in and do the water sampling, and they have to send me the results, and MVP doesn't get a copy.
I'm also, many roles of work for my uncle. I'm also the assistant prosecuting attorney where I live in Lincoln County. And we recently, and actually if something would go wrong, if there would be a leak, we're working with a law firm. We've actually filed it, and we have a hearing Friday against Freedom Industries and also West Virginia American Water. As you all, I don't guess it affected you all here, but down in Lincoln County, we were part of the big leak down there. And so we filed a suit, and what we're going to have them do is to actually do some realistic studies about what the potential damages to, in particular, children under 5 that would occur. But what I would say, if there becomes a problem up here, there is nuisance law. We actually enacted in Lincoln County, and I don't know your all's county commission and whether they would be willing to do that. We took a lot of heat in it from Lincoln County, from the gas industries and so forth, about enacting a nuisance act, which we're using to, in conjunction with the regular laws that deal with nuisance, to file this suit. But if something would happen and there would be some real problem with the water, I think that the lawyers I'm working in this case would certainly be willing to take a look at that. So, I mean, there is something you can do if there truly is a problem that causes problems on a global scale up here. Now, in terms of just having it tested just on, in the context you're talking about, I'm not sure, but I am involved in litigation with these companies, and I know that they hired many lawyers to come to our commission meetings to fight us passing the ordinance, but our commissioners stood up and did it anyway. So I believe if that kind of issue would arise in the future, you can find lawyers that are willing to come in here and assist you with that. And certainly if that came an issue with here, you could call us in Lincoln County and we would get you in connection with the lawyers that we're working with.
Well, yes, ma'am.
We have been contacted by MVP for access road, a 40-foot wide access road, and some areas decided for storage, which is river and all that. The public road that comes there is not that big, and there are bridges that are really crooked and 40 degrees bend. How does that work? How do they want to have 40-foot access road from us when
there's a
doubt
public road?
if they can get through the public road?
Go down to where they're fracking and I guess Wetzel and some of those, and you'll see. They've got dirt roads out there, they're videos of huge trucks carrying the fluids that they frack with. Over on the side, they're stuck, or they're turned over because the roads can't support it. They're destroying the roads.
So they do it anyway.
Yeah, and a lot of times they'll make improvements to those roads. I mean, it's a big money project. We're talking about billions of dollars. So, you know, they can make improvements to the existing public roads to allow it to handle their equipment.
One side is a creek and the other side is usually a farm.
So I've got a question for you. Did FERC give them the power to get that road from you?
No.
No, they're just negotiating for
They
it.
approached us with an offer.
Well, it's yours to take or leave.
No, we don't, of
Yeah.
course we don't.
Yeah.
But I was wondering about what happens to the public road. How can
The
they
other road.
access when they can't even go through the public road?
Yeah, it's a problem. Like Chuck says, they oftentimes do, I mean, there were some folks in here, it wasn't a gas or a pipeline project, but I know a couple that was in here earlier, I think it looks like they might have had to go with a big quarry truck. Had a similar thing. The truck was on too small of a road, and it tipped over right by their spring, and, you know, caused it was quite a headache for them to get them to remove it without completely ruining their spring.
And we've dealt with those issues in Texas already, because fracking's been going on there in the because their interest is not in keeping everything pristine. They'll use it and be out.
So
Have
along
a
those
question
lines,
over there.
That's my question. When they're out, has there ever been a time, or is it a possibility that this easement is just temporary for construction purposes?
If you negotiate the terms to that
And then
effect,
afterwards, they have no more access to your land?
you could negotiate terms like that on a grant of an easement, yes, you could.
and if you're describing it as temporary at this point, is it clear to you from what they're asking for? And in the plans, in the MVP mapping, that it's temporary as opposed to permanent? For construction. It sounds like it would be. And then again, along those lines, you know, we can talk about this in the context of an easement or eminent domain, or is that possible? Can you do that? I mean, I'd encourage you to come to the DEQ hearings in Virginia. And I mean, I think this is an idea that's really, that I hope catches on, that you should talk to Virginia about these questions that are happening in West Virginia. And that physically, you know, it's in my ethic, we don't see that state line or county line as a differential. This is a community that MVP is bearing down on, and that government agencies and people, individuals along the way, can bound together to challenge. So that's the point I want to make here in closing. And I would encourage you folks, if you have more questions, to sit tight, because I'm going to ask these guys to sit tight for a little bit longer if they want to stay. But I need to, you know, kind of, wrap this program up a little bit. But I do want to say that, you know, I'll ask you to be with me on a way of thinking at this point. Ben, Isaac, Appalachian Mountain Advocates are here as a nonprofit. They are challenging this pipeline. They're pipeline fighters. Power and every one of your nonprofits, and you, by virtue of the fact that you're sitting here, are pipeline challengers. You're questioning this. I'm going to ask you to keep hold of that thinking. Everybody, to Ben's right, in legal counsel here, you guys are insurance. That's what we've invited you here for. No offense, but that's the way I think of it right now. That's the way we've got to think of it. I think, and to the extent that, you know, Ben and Isaac are challenging through the FERC process, challenging the tolling orders. I can tell you in an ACP and MVP collaborative meeting this weekend, you know, I'm aware of ideas within the nonprofits, more than ideas, litigation strategies to challenge eminent domain for private gain. the question of the fact that MVP, that MVP and ACP, FERC, has not issued a programmatic environmental impact statement, a programmatic analysis of the need for this pipeline in the Marcellus and Utica shale regions. That's not Pollyannish or a pie-in-the-sky request. It's been done by several agencies and other projects throughout the 2000s. It's just that FERC says, we've never done that before. Their parent agency, the Department of Energy, has done those things. A PEIS would slow the train for us. And there are people who continue to ask that. And that would be part of several litigation strategies. Retiring Chair Norman Bay, wrote a leading opinion on it at this point. So there's eminent domain, the PEIS, due process questions, from open houses to scoping hearings to so-called public hearings, to the fact that there's no index, to the absence of access to technology for the rural poor, for some elderly, that people can't participate in this process. The wrongs in this process run on. We don't have all the avenues of relief we would like. We have avenues. And again, if we're not using that muscle, we're going to lose it. My ask for you all tonight is that we look around and continue to talk to one another. Whether our strategy be legal, Perriello and other elected officials, that's a sound opportunity to participate in. That's not fluff and it's not frill. To participate in that process is important. The DEP and DEQ processes are important. They're not litigation strategies. We've got to get out of the box. And we have to think of, there are other strategies we have to recognize and then participate in. Everything counts at this point. I'm not an especially great fan of football, but we're in the fourth quarter, and the game is still on. Thank you for being here.